Yes, get ready and start. Recently, in Suresh Kumar versus State of Haryana and others 2025 INSC 550, it was reiterated that delay alone cannot be a ground to deny compensation lawfully payable when such denial would result in discriminatory treatment among similarly situated landowners. Applying the aforesaid principles, this court is satisfied that the delay of 1392 days in filing the appeal is neither deliberate nor attributable to malafide. The explanation placed on record reflects a bona fide and mistaken belief that the appeal had been instituted along with those of other similarly situated landowners. The subsequent lapse in refiling, though negligent, is procedural in nature and does not disclose any design to abandon the remedy. In land acquisition matters where rights arise from the compulsory deprivation of property, a hyper-technical approach to limitation would defeat substantive justice. More importantly, refusal to condone delay in the present case would result in a manifestly anomalous situation, as landowners whose lands were acquired under the same notification covered by the same award and reference proceedings would receive disparate compensation for identical parcels of land. Such differential treatment would offend the principle of equality and parity, which lies at the core of land acquisition jurisprudence and flows from Article 14, read with Article 300A of the Constitution. Courts have consistently held that similarly situated landowners cannot be subjected to unequal compensation merely on account of procedural delay, particularly when the enhancement has already attained finality in respect of the same acquisition. At the same time, equities require balancing. The consistent course adopted by the Honorable Supreme Court in comparable circumstances has been to protect parity while denying interest for the delayed period so as to prevent unjust enrichment. Accordingly, while condoning the delay of 1392 days in filing the appeal and 2359 days in refiling, it is directed that the appellant shall not be entitled to interest on the enhanced compensation for the delayed period of 1392 days in filing and 2359 days in refiling. On merits, it is undisputed that the appellant's land forms part of the very same acquisition proceedings which culminated in the judgment dated 5/7/2019 in RFA number 4101/2008 titled SHIDC, now SHIIDC versus Rajesh Kumar and others. The state has fairly conceded that the factual matrix is identical. Once compensation has been judicially determined for lands forming part of the same 4 of 5 RFA 53-2013-2026 PHHC 90 notification and the said determination has attained finality, denial of identical relief to the present appellant would not only be inequitable but legally indefensible.